Okay, hi everyone. Good evening. Again, I'm Leslie Sultan. I'm on with my colleague Christina Sammartino. Thank you for joining us. And today we're going to talk about trusts. So, quick little disclaimer, the contents of this presentation, as well as any answers that are discussed during a Q&A session, are provided to you by way of general legal information only and should not be construed as legal advice. If you need help with a specific legal situation, we would recommend that you consult with a licensed attorney. And again, this is being recorded for the people that are coming on later. Okay, so I'm Leslie Sultan. I'm an estate planning attorney. I'm also a working mom. I have 2 children. Their ages 6 and 8. I founded my law business in 2010, and me and my team, we take a very personal approach to every case that we work on. So you might hear us talk about some cases, and just know that, that's that particular situation. Each situation might be different. When I'm going to do the first half of the presentation, and then Christina will introduce herself and go on, and then we'll both be available for the Q&A at the end. All right, so the first thing we're going to talk about is probate, and a little bit of the history of probate, because most people might have heard of probate, but don't necessarily know what it is or what the history behind it is. So for any of you who have gone through a probate process or are kind of familiar with it, basically it's the process to have a will admitted to the courts so that it can be validated and the assets for the deceased person can be distributed. What most people don't realize is that probate is not designed to help the families get the assets. Probate is actually the outcome of creating a way for creditors to come after family or the deceased to get the money that's owed for them. And if you think about it, it kind of makes sense. We're going all the way back to like England. Back in the days, they had different courts, and I won't go into all of that history, but it used to be that people would lend money to someone, and if that person died, they would go after all of their family to get the money back, which of course is not fair. It became a very big conflict within families. So the courts needed to come up with a system where creditors would still lend money, because we need a system where if I'm dying or if I'm sick, I need to borrow money to pay my medical bills, someone will give me that money. Or if I'm old and I need money, I can borrow that money, but still have a way for the creditors to recoup it. Otherwise, creditors won't be giving anybody money. So they came up with this probate system. So basically, once somebody dies, the estate files a claim, and the creditors get to come in and take their money. So what you don't hear me talking about right at that point is the family and how the family gets their inheritance. That comes after all of the creditors are paid. So, I'd like to preface that, the trust and the history of probate, because I want you to know where this system is coming from and ultimately how to potentially avoid it. So what probate is it's essentially a lawsuit you file against yourself on behalf of the creditors that's paid for by your estate out of the money that you saved. So family really doesn't come into play until later. It's a very public process. If you've ever done it, you'll know that the minute you file a probate proceeding, you start getting notices from creditors, from businesses, even from attorneys asking, hey, hire us or whatever, because it's a public system and there's people that are clawing through that system to find out who's filing stuff. So if your probate is something you're not interested in, having the public at large know what your assets are, know how you want your assets distributed, you're going to want to avoid probate. And that's we're going into the talk about trusts. So, some people say, well, if I have a will, can I avoid probate? And of course, the answer is no. So whether you don't do a will or you don't have a will, both are going to wind you up in your family up in the probate courts, or in New York, we call it the surrogates courts. You can't leave a will and have your family take that will to the bank and say, hey, I've got my will, I'm supposed to have all this money, please give me my money. The bank has no way to verify that that will is valid, that you didn't just make that up in your kitchen and have a couple people sign it and bring it into the bank and try to steal someone's money. So it has to go through the court system. And during that time, the assets are frozen, no assets can be transferred. If you have like rental property, you can't collect the rents, you have to pay for the deceased person's funeral expenses, you can't get reimbursed for that until everything is resolved. And unfortunately, in New York, depending on which county you live in, this can take a very long time. I mean, we have cases that are in Brooklyn that are taking years. Nothing can be done. The property for one of my clients is in foreclosure. None of the tenants are paying. It's just like a huge mess. And my client died and the family's stuck dealing with it. Fortunately, once somebody is appointed, then things can start moving along. But obviously we would like to find the quickest way to resolve an estate as possible. And sometimes with a probate, the judge might have to require another additional motion for the sale of a house or the movement of some assets. They're very cautious about how assets are transferred. So there's a lot of scrutiny, and notice has to go out to everybody who could inherit, even if they were disinherited. So the probate court has to make sure that everybody has their chance to dispute and fight the will. So again, it can be a really big hassle for families going through the probate process. If you don't have a will, the state has a plan for you. So the first thing you can do is Google what happens if I die in the state of New York without a will, and you're going to see how the assets are distributed according to the state. Usually the courts then require a bond, and so now the person has to pay additional fees in order to get access to their inheritance. And again, no funds can be accessed. All accounts are frozen until that's resolved. So hopefully, the next question or the question in your head is, how can I avoid probate? So this is where the trusts come in. So obviously one of the best ways is to create a revocable living trust and have the trust own your property and your assets. So what does that mean? So if you have a bank account or a house, you're going to retitle the asset into the name of the trust. You're going to take your name off of the bank account. So it's no longer Leslie Sultan's checking account, and it'll be the Leslie Sultan Trust bank account. The beauty of a revocable trust is I am the grantor. I'm putting my stuff into the trust, but I'm also the trustee. So I have control over those assets. I'm still writing those checks. I still have the ability to pay my mortgage, to refinance my house as the trustee of my trust. I have control over it. And then the minute I pass away, the assets automatically transfer to the successor trustee, whoever I've named to take over, and they will distribute it to the beneficiaries. The beauty of this process is I didn't mention court, because we're not going through court as long as the assets are in the trust and the trust is written out. And again, the new trustees do not need any authority to maintain the trust. They can immediately start paying bills, collecting rent if there's rental income or a business involved, and continue on. So to define a trust, it's a living trust is used to describe a trust you create during your lifetime. It's a written document that serves as a contract between you and yourself and your estate, and determines how your assets will be handled in the event of your incapacity or your death. Now, incapacity is really important because sometimes, for example, my mom has a trust. She's still alive, but she has dementia. So she's not able to manage her assets anymore. But because she put them into the trust, the successor trustee is able to manage them for her without, again, court intervention. So one of the questions that we get a lot is, does a revocable living trust offer asset protection? So in this trust that I'm talking about, where I have control over my trust and my assets, it does not give me asset protection. So it's a great tool used to avoid probate, protect my privacy, and help me to manage my assets and potentially minimize estate tax. But if I have control over those assets and the trust, it does not give the asset protection that some people are looking for. So in a few minutes, Christina is going to discuss how to get asset protection using a trust. But essentially the basic concept is a third person has to control the trust. So an analogy that I like to use is a purse. So if I create a trust, I have a purse. I put my wallet in my purse, my keys, my checkbook, credit cards, everything's in my purse, and I'm walking around with that purse. I control it. I can take my checkbook out, I can write checks, I can sell my house and put the money into my purse. Everything is within my control. The minute I pass away, they just take that purse off of my shoulders, give it to the successor trustee, and now they're in control of the purse, and now they're writing the checks and they're selling the house, okay? So with a revocable trust, I have control of the purse. If I want the asset protection, I have to give that purse to somebody now while I'm alive, okay? So that's the difference, and we'll go into a little bit more details later. So I guess that's the summary of the revocable trusts. So I'm going to pass it on to Christina. You'll see the slide in a minute. If you have any questions and you didn't want to ask them during the group, you can always reach out to us using my contact information. Hi, babe, my daughter's sneaking in here. And then I'll put it up again later. But meanwhile, we'll go over to Christina, and go ahead, Christina.
Well, thank you everyone for joining us tonight. I'm happy to be here. I'm also an estate planning elder law attorney, working mom. I have 2 children myself, young children. And I really came into this field in order to educate people. We want to get out there and educate everybody on the importance of having estate planning and having trust and the different types of trust. As Leslie said earlier, if you don't have an estate plan, if you don't have a will, New York State dictates how your assets are going to be distributed. Having said that, I'm going to kind of dive into what are the different types of trust that we were talking about, revocable trust versus irrevocable trust. So Leslie, love the pocketbook example. So with a revocable trust, it's very similar to a will, that it tells the people, you know, how you want your assets to be distributed upon your death. So instead of an executor that you have in a will, you have a trustee, and you tell your trustee how you want to distribute your property. It's private, so it's never made public. Nowadays you can go right online and put in somebody's name on web surrogates and take a look at their will. With a trust, you don't have that. It's less costly. People hear trust in general and they hear the dollar sign next to the cost of creating a trust, but they're not advised that when you die and your children or your spouse or whomever it is, your loved one goes to us or comes to us and they sit down and they say, oh, I have this will, I have so-and-so's will, I have to probate it. We're basically taking more money from them than what it would have cost to have a trust done, because it takes our time and it takes petitions and documents and court fees, filing fees. Filing fees could go up to $1,300 for surrogates court. So with a trust, you have that ease of administration. There's less costly, less time consuming. Currently for wills and probate, it's taking at a minimum of 9 months from when we file petitions to getting letters. And then the statute state that creditors have 7 months to make a claim against the estate. So an executor, administrator is really not supposed to make distributions until that 7 months have passed from the date that they're appointed. So it could take 1.5 years before your executor administrator is really allowed to make distributions. With trust, I always say if you die at 10 o'clock, at 10:01, your trustee could distribute your trust. It also avoids ancillary probate. Ancillary probate is for people who own properties in more than one state. We have a lot of clients who are snowbirds or who own multiple properties. They don't realize that, okay, you may have a will because you live here in New York, but your house in Florida that you leave in your will to your daughter, you now have to have a Florida attorney probate an ancillary proceeding down there once the New York one is complete. Revocable trust, as we said earlier, there is no protection for Medicaid. So that's a big difference. With irrevocable trust, very similar to revocable, except you cannot be your own trustee. The assets in your trust are protected from Medicaid once the look-back period has come. We'll get into look-back periods a little later. It's harder to change or amend irrevocable trust, and it offers a lot of protection. We hear irrevocable, you hear me say it's harder to change, you don't have control, you don't hold the pocketbook. However, our irrevocable trust, there's three main, very important things. First, you as the grantor always retain the right to change the trustee. So if you ever said to your trustee, go in that pocketbook and take out my checkbook, and they say, nope, I'm not going to do it. You come back to us and you say, daughter A is gone and we're putting daughter B on. The second most important thing is you always have control as to who your beneficiaries are. So you leave everything to your son and your daughter, who's also the trustee, says, nope, I'm not handing you your checkbook out of your pocketbook. You remove her as a trustee and you remove her as a beneficiary. So you always have the control over who your trustees are and who your beneficiaries are. You also have control over your house. If your house is placed into the trust, whether it's your primary residence or vacation property, you have the right to say, I want it sold. Your trustees can never sell it without your consent. And if you want to sell it and they say no, again, we just remove them. We remove them and replace them. So while for Medicaid purposes and irrevocable trust, you lose control of holding that pocketbook, but not what happens. So that's really, really important, because I get a lot of times clients who hear irrevocable, they get nervous. They don't want to really plan that way yet. I'm too young, maybe not, I'm healthy. But I feel people 60s and older should really start thinking about irrevocable trust. Long-term care is becoming super, super expensive today. It could be $35, $45 an hour to have somebody come into your house to help you. And so, you have to plan out, because there's changes coming down to the law, which we'll get into. Let me go to our next slide, because we're really going to kind of talk about, we went over this more. This is just a little summary. Revocable, grantor creates it, updates it, can amend it, goes in, there's no protection against creditors, and grantor retains all the control. Irrevocable, we have limited changes, it allows for governmental benefits, and it protects assets. So these are like the most important differences between the two trusts. But the importance of the irrevocable trust is for Medicaid. So what is Medicaid? It's a joint federal and state program. Each local government, so we have DSS, Department of Social Services in Nassau and Suffolk, and HRA, Human Resource Administration in the city. There's different guidelines that vary for the federal guidelines and programs from state to state. And what it does is it pays for long-term care that is not covered by health insurance. So we all have health insurance. When you turn 65 and over, you get Medicare. Sometimes you have a supplemental, but Medicare, they'll cover rehabs up to 100 days with a copayment. But if you needed to go into a nursing facility, or you needed an aide to come at home to help you with your activities of daily living, that is not being covered by Medicare. And 90% of the time is not covered by a supplemental. So what happens? What happens if somebody starts to become ill? There's two different types of Medicaid. So there is nursing home Medicaid and home care Medicaid. So in order to qualify for Medicaid, you have to be 65 years and over, blind or disabled, a New York resident, and unable to perform at least 2 activities of daily living. So your activities of daily living is your bathing, toileting, grooming, dressing, eating, ambulating, and transferring. So if you can't do at least 2 of these, then you would qualify for Medicaid. There's also an income and resource test. So resources are your assets. Currently, you can't have less than, and I apologize, this slide has an error. If you can't have less than $30,000, more than $30,000 in your name. It actually just went up in February of 2023. It was at 28, and then they recalculated to be $30,160. And this includes everything: cash, stocks, treasuries, life insurance. Cash value of life insurance policies is counted in that amount. So that's really important. Most people don't know that. Whether you own it by yourself or with your spouse, if your name is on it, if you have a joint account with your child, that counts as part of your resources. Nursing home Medicaid has a 5-year look back period. So if we created a trust now and we transferred your home into the trust, we would have to wait 5 years before you need to have Medicaid services, which is called institutionalized Medicaid, in order for your house to be protected. All of your income gets paid over to the nursing home, and you could keep that $30,182. If you don't meet the 5-year look back period and you need a nursing home Medicaid now, there are other ways to save some of your assets, but it's only about 40%. That's why it's so important to think about irrevocable trusts now, because the worst case scenario is you never need Medicaid and your assets are protected. Without it, you run the risk of one day needing long-term care and it being too late. We then have home care Medicaid. Now, this is the big one. Right now, there is no look back period. Well, you can have $1 million, we could transfer it out, and in 30 days, we could apply for you. Coming March of 2024, so now we're less than a year away, they're going to be implementing a 2.5-year look back period. This is going to be huge for people. This is where an aide comes in to help you. You need to shower. You need an aide to come in to help you shower, to toilet you, to help feed you. This is going to change. It's going to be significant. So again, planning now, at least putting your house in so your house is protected. You could always spend your asset. We could spend your money, but your house is usually one of your largest assets. So why not protect something you work so hard for? So home care Medicaid, you are allowed to keep $1,677 of income and have $30,182 in assets. There's ways, if your income is above the 1677, there are ways to keep your income as well with something called a pooled income trust. Again, this gets very complicated and complex. And that's why you should have an experienced elder law attorney helping you. With Medicaid trusts, that's the irrevocable trust we were talking about earlier. An important thing is whether you're in a nursing home or home care, the income only goes to the grantor. So if you have stocks and bonds or brokerage accounts in it, and it generates income, you're entitled to all of that income. So it's not that you're giving it up completely. You get all of the income, all the interest. If you have a rental property, you could get the rental. But whatever you put into it, you're not supposed to take out. So the principal of the house, once you put in, you can't get back. So if you have a house in there and you sell it, the proceeds of the sale would go into the trust. If you wanted to buy another home, you could with those proceeds. If you wanted to take those proceeds and invest them, you could, and then you would get the income from it. So there are very tricky nuances of irrevocable trust. And again, the importance of having an experienced elder law and estate planning attorney who can walk you through it. We'll go into now some inheritance and some subtrust and how to protect your inheritance and assets. So we all work very hard to have inheritances. We want to pass down our legacy to our generations. A lot of times there's reasons for creating subtrust within a trust or even a will. But I'm focusing more on trust because I am leading all my clients to trust rather than wills, because the probate process is just taking far too long and becoming way too costly. So some of the reasons for creating subtrusts is if you wanted to protect assets from creditors. Sometimes we have estate tax trust or credit shelter trust when we're worried about estate tax planning. If we're worried that a beneficiary may get divorced, there's a reason you can have something called the lifetime trust so that their share remains in a trust for their lifetime. That brings me to number 4. If an individual you think is incapable of managing their finances, maybe there's nothing wrong with them, but you just know they like to spend money and they're big spenders, and you want to make sure your hard-earned money is not, you know, being blown away at the casino or on foolish things. Another reason is with minors. I always say we don't want an 18-year-old who's now no longer a minor to inherit. Could you imagine you passed away and you leave your hard-earned 80-year worth of earnings to your grandson who's 18, and he comes into, let's just say, $500,000, and he goes and takes his new girlfriend of 2 days around the world. I always jokingly tell the story of my brother when my grandfather passed away, and we got a whole $15,000 of life insurance that he left us. My brother had to be about 20 at the time. and he had some money for the first time in 20 years. And there was a store in the mall, Shopper Image, I think it was called back then. And there was a massage gaming chair for $1,000, and he swiped the card and he bought it. And we joke today about this all the time, because as a 20-year-old coming into $15,000, you thought it was so much money, it would never run out. And why not buy that $1,000 gaming chair that's going to massage my back while I play my games? So I always recommend doing a trust, a sub-trust, and leaving at certain ages, a percentage, maybe 1/3 at 20, and 1/3 at 25, and the rest at 30. This gets tailored to each individual. No two estate plans are ever the same. So sometimes there's really good reasons. Another reason is, well, what happens if one of your beneficiaries is a special needs or starts receiving their own Medicaid benefits? Again, we do planning today, and people don't know what's going to happen in 20 years from now. So there's many different reasons why attorneys do sub-trusts within a trust. That brings me to my supplemental needs trust. So some people receive governmental benefits, and we want to make sure that while they're receiving those governmental benefits, that we could still leave them something. We don't want to just exclude a loved one because maybe they were born with, a defect, or maybe they're on Medicaid now themselves. Maybe I want to leave it to my sister and, she's receiving Medicaid, but I want to make sure that other things are cared for. So we have a trust called a supplemental needs trust. And this says that the funds get deposited in there into this sub-trust and could be used for the benefit of the beneficiary that won't, that's there to supplement their benefits. So it's not to pay for things that their benefits would pay for, like if you're getting food stamps for food or for health insurance, but for things that are not covered, like your cell phone bill or a vacation if they need it, or their hair and their nails, or if they have a pet and pet food, a lot of things that governmental benefits won't cover. So I know I went into a lot with all the trusts. I know that it can be very confusing. So I know we're happy to take some questions at the end, but I hope you guys enjoyed that.
Thank you, Christina. So, yeah, again, our contact information is here. If you have questions that you didn't want to ask in the group, we can open it up for chat questions, or if you wanted to answer. In the meantime, we'd like to share some celebrity stories, because we can learn a lot from how other people have done their estate plan. And, it's kind of like, we know who, Robin Williams is. That's kind of like someone we're familiar with. So I'll just go ahead and give short little snippets of each of these cases, and Christina can help explain why, what went wrong, or what we can learn from it. And then along the way, if you guys have questions, please let us know. So Whitney Houston, as you guys know, was married to Bobby Brown, and they had a daughter, Bobby Christina. And as many of you know, Whitney Houston died, unfortunately. But also she had divorced Bobby Brown. I forgot to mention that part. Luckily, Whitney Houston did do some estate planning. She did a will. Okay, so we know all about it because it's public and it went through the probate courts. And in her will, she did set up a trust for a daughter, Bobby Christina. And like our Christina mentioned, she set it up in stages. So Bobby Christina inherited the first third at 18, and then was scheduled to receive another portion at 25 and another portion at 30. If many of you know, Bobby Christina died, unfortunately, the same fatal death as her mother. And Bobby Christina did not do estate planning, which is probably a good thing under the circumstances, because she had like a questionable boyfriend, and maybe she would have left it to him. So, pop quiz, what happened to Bobby Christina's assets? And she didn't have a plan. Her estate had a plan for her, right? So who do you think inherited all of that portion of Bobby Christina's money? Her father, Bobby Brown, Whitney Houston's money went to her ex-husband. So that's, unfortunate. Luckily, she had those other ages that said that at 25 and 30, the rest would go out to her. So that portion was able to be preserved and went to the estate of, to Whitney Houston's sisters. So Christina, what did we learn from this example?
Yeah, that's why it's really important to have an estate plan. And I find all too often I'm coming across younger generations, myself included, my generation included, I should say, that they think, oh, well, I'm only in my 20s or 30s and I really don't have any assets, so I really don't need an estate plan. But that's incorrect, because most of us are going to inherit something someday. And if we don't have it, then it's going to pass through how New York says it's going to, and maybe we don't want it that way. Again, if I'm going to inherit from my parents and I pass away, do I really want my spouse to get it? If I don't have children, well, my spouse is going to get all of it, which means he's going to get my parents' inheritance. Is that something I want? Or, should it go to a sibling? Or if I'm not married, and my parents are divorced, such as Whitney's example, do we want it to go to the other parent? So the biggest takeaway is make sure you have those estate plans in place.
Yeah, ideally she would have done a lifetime trust for Bobby Christina so that Bobby didn't get it. Bobby Christina didn't get it, or would have gotten it when she was much older. So she did some things right, but yeah, otherwise not so well. We do have a question from Amy. Do you need a will or trust for a 401k/IRA account that has beneficiaries designated? So that's a great question. We like this question. So the answer is going to depend. So obviously, a beneficiary designation is essentially a probate. It avoids probate. Okay, it's like a contract. The amount is paid directly to the beneficiary immediately upon death. You send them your death certificate, they write a check. However, who is that beneficiary, right? So is that beneficiary a minor? A minor cannot inherit. So if you're trying to name minors, you're going to have an issue where we're back in court and you didn't really do anybody favors, and somebody has to petition to be the guardian for the inheritance for the minor. What happens if that beneficiary has died and you haven't updated the beneficiary designation? So yes, in theory, it can work, but we always recommend that a trust be done and you name the trust as the beneficiary. And this basically solves all the problems, because if there's a minor, the trust will say any money to the minor is held until their ages A, B, and C. It's going to say that if anything is listed for a beneficiary who's deceased, then it goes to this person instead, or their children instead. So it's able to take that planning that you're doing and really make it work in different scenarios. So I don't know, Christina, if you wanted to add anything to that.
No, you hit it right on. It's case by case scenario. A lot of times it's, if you're married, it should be husband and wife first. We don't really have to worry about a trust per se. But then the contingent not being kids, especially, I know we're going to talk about 401s and 401ks and IRAs, but life insurance is a huge thing. People don't realize that they put their minor child down as a beneficiary. And then time comes and the insurance company is asking for their guardian, wants a guardian appointed. And you're like, what do you mean a guardian? And so, it's case by case, but most of the time a trust is really preferred.
Right. Another question, how much does a trust cost for a single woman with no kids? Okay. So obviously it's going to depend on, which attorneys you're using. For us, we do a flat fee. So trust costs X amount. Our fee, for example, for a trust is $5,000. That's going to cover also all of the other estate plans. So we do what's called a pour over will, which is like a backup. So just in case something didn't get put into the trust, right? It's not in the purse. The will move it into the purse if it's needed. We do power of attorney, healthcare documents, everything is covered. So it's a flat fee, and then, you pay and you're done. So then, some people might feel that that's high, but as Christina also mentioned earlier, it's probably going to be a lot higher for your family when they have to go through the probate process. And keep in mind, whatever you spend on a will, they're going to spend for the attorney on top of it. They're going to spend on court fees in New York. The filing fees in the courts can be as high as $1,250. And that's the average cost, right? Anybody with an estate over 500,000, that's the fee that they're paying just to start their case. That doesn't include anything else. So, yeah, so really, if you're going to consider a trust and you have no kids and no husband, you're really doing it for the benefit of the people that you are leaving the money to, whether it's a organization, a foundation, your family members. We call a trust a gift that you give to your family because you're taking care of everything during your lifetime and they're just going to sit back and receive the benefits.
Yeah, and just to go off on that, even with your children, your spouse, not so much because most of the times your houses are probably owned jointly, but with your children, you also have to think about if you just have a will and now it's got to go through the probate process and it's taken at least 9 months from start to finish. And I'm telling you now that no child is running into an attorney's office the day after you pass away and to say, oh, I need to do this right now. So if you're thinking about a year turnaround time from when you pass away to when your kids have the authority in their hand to sell your home, they have to continue, if you have a mortgage on your house, paying your mortgage, your utility, your taxes. If you're in Long Island, they could be $20,000. And if your children own their own home, now they're paying their own mortgage, their own taxes, and yours. And then you run the risk of, if you have multiple children, maybe one child could afford it and the other one can't. And then, it's very burdensome again for your family. Whereas, as Leslie said, it's a gift you're giving now to your kids to say, hey, listen, I took care of everything when I pass away. The minute later, you may contact a real estate agent and an attorney to say, okay, put it up for sale, or I want it, put it into my name.
Yeah. We have another question from Donna. She's saying, hi, if I have a mortgage on my home, can I still put it into an irrevocable trust? And this is a really great question. So the answer is possibly. So yes, you can. All right. You can always transfer the house into the trust. However, there is a risk that the lender might recall the loan, because if you think about the concept of you have the purse, you're in charge, the lender lent you the money. They qualified you, right? They did all that background check, all the finances. They know you're going to pay. But once you put it into the purse and give the purse to somebody else, you've given control of that asset to somebody else. The banks don't always like that. So sometimes what happens, depending on who your lender is, you might have to refinance with a different lender, or you might have to pay it off. Or we have some clients that just do it and they don't tell the lender, and the lenders don't usually find out. We've done a lot of trusts, both revocable and irrevocable. I, in my career, have never seen a bank actually recall a loan because it was moved. But in some instances, they will tell the borrower to take it out of the trust. So obviously we would want to avoid that by either by immediately going to a different lender or some other way to protect the asset. And then just since we're on this topic, if you have a mortgage and you're doing a revocable trust, you absolutely by law can transfer it to a revocable trust. All right, I guess there's nothing to add to that. I could talk about Robin Williams. I love telling celebrity estates. Robin Williams did a trust. Go Robin. He had his third wife at the time that he died. He basically set up all of his assets to be distributed to his children, and the house that he lived in with his wife got to remain for his wife for her lifetime. But there was a problem with that, because everything that Robin Williams owned was in that house, which included, his lifetime worth of assets, right? His shoes, his awards, all kinds of stuff that his kids wanted. So unfortunately, Robin Williams didn't have the foresight to clarify what could happen to those assets. So the family wound up in court fighting over access to the house and the assets that were in there that they believed that they were entitled to. Fortunately, they settled, but Yeah, that's the Robin Williams story. Christina, did you want to add anything around that?
No, again, it's just with having a will sometimes too, and things with the court, it could always be a fight. And so trying to avoid it with private documents, with private things is much more safer. It may cost more now, but in the long run, it's not going to.
Right. And we don't know how that happened. Maybe he was rushing to do it, but sometimes we have people that come to us and they've downloaded a trust online and they've done their own estate planning, so to speak. And it's missing, again, those details of what, Christina and I have seen through our probate experience and, just our experiences as lawyers, knowing what we know how to steer people out of some of these conflicts. And so when people go the online route and they get this cheaper form, they're losing that experience and that knowledge that would have guided them to avoid these mistakes.
Yeah, and just to go off track, we know we're talking about estates and trusts and wills, and that was really the primary focus of this webinar. But that's really important for something called a power of attorney, which is a legal document whereby you, the principal, appoint an agent to, what I say, conduct the business of you, so they could pay your bills, mortgage your property, create trust for you, fund the trust for you, do deed transfers, do all of the things you're able to do. And I'm running into clients who went online for their parents and printed out a power of attorney and had mom or dad sign it. And now they don't have either the gift giving authority to gift the house into the trust, or it wasn't properly signed, or it's the wrong document because New York has a very specific power of attorney, New York statutory short form. So having your experienced elder law attorney is also super important. And I say elder law estate planning because there are other different types of attorneys out there. I had a client recently who, on a guardianship matter I was appointed by the court on, they went to a family friend who didn't practice in this area during COVID because they were afraid. Mom was elderly and he did a power of attorney. And now 3 years later, they're going for guardianship because the power of attorney is defective. So while, again, cost efficient, you think you're going online, printing something out, it's going to cost your kids so much more money later on. This power of attorney that they paid an attorney to do who really didn't know what he was doing is now costing them $15,000 in a guardianship proceeding. So, just think about those things, especially when you're hiring an attorney. Do due diligence, talk to them, see them, ask questions. We love questions. We're always here to answer questions.
Yes. So we're getting close to time. It's 7:46. I'm willing to stay until 8 o'clock to answer questions. I'm also happy to talk about Hugh Hefner and Heath Ledger for anyone who wants to stay on. Again, here's our contact information to reach us. I don't see any more questions in the chat box, so I'll move on to telling the stories of the other celebrities that we had, and then we'll end the session. So Hugh Hefner, right? He's the founder of Playboy magazine. I was like so curious to hear what his estate would be like. I was sadly disappointed. Hugh Hefner did a trust. Go Hugh. And he left everything to I think it was his third or fourth wife and his 4 children. It was really straightforward. There was no drama. The only issue and the only reason we even know about it is because there was like one teeny little detail that was left out regarding some royalties for a magazine. And so it had to go through the courts to be included in the trust, because again, what you put in the trust is controlled by the trust. But if something's not put into that trust, it stays out. It has to go through the probate court. So unfortunately, there had to be a little bit of court action, but otherwise he did a great job. Everything was distributed well. There was a little bit of controversy from former Playboy bunnies who were trying to sink their teeth into the estate, but it was protected by his trust. Anything you wanted to add on that, Christina?
No, I think you got it covered. That was a good one.
The other thing that came out of that, if you ever want to Google it, is that he did put in a clause about substance abuse in his trust. So he made it very clear that if any of the children that were supposed to inherit had a substance abuse problem, they could not inherit until they could prove that they were clean for like at least a year. So we see that in a lot of estate planning documents. So whenever there's a concern, the way to protect it is putting specific language in there for those kind of things. Whether it's substance abuse, gambling, whatever it is, a trust can really protect against that. In the meantime, I did get a question from Donna. Is a trust an effective tool to protect my assets from potential creditors? What happens when a creditor puts a lien on the trust or sues the trust? Christina, you were kind of talking about it, so I'll let you answer that one.
So it all depends on when the creditor emerges. So as we were talking about earlier, really, if you don't have an estate, creditors have nothing to attach to. But if you, let's say we're in a car accident and you know that you're going to be sued, or you own a rental property and something happens and you know you're going to be sued, and then you do the transfer, you create an irrevocable trust and you move assets into it, no, there's going to be no protection because the court is going to say you intentionally did that. But if you put things in there, and creditors such as credit cards or things like that, they very rarely attach to the trust because they don't know about the trust because it's a private document. So, creditors have a right to make a claim against your estate through the surrogate's court, but not really with the trust because they don't know where it is. They don't know where it exists. You don't have to say, oh, hey, American Express, here it is. So that's the benefit of it. But if you have been sued, or an action was starting before, yes, there's a possibility. Nothing is ever guaranteed.
Right. So yeah, and this question could go a few different ways, but just to be clear again, a revocable trust where you have control of the assets in the purse does not give you asset protection. So if you can write the checks, if you have control, then creditors can come after those assets. But once you put it into the purse and you give it to the control to somebody else, that's where you get the asset protection. So that's why when we say for Medicaid, for example, put your house into the trust and give the trust to the control to somebody else, Medicaid cannot then put a lien on the house, nor can any other creditor, because it's not under control as long as we go through that 5-year look back period. So, and then the other way to get some asset protection is if you're running a business, you create some LLCs. If you have a rental property, you own it in an LLC. That gives you some asset protection for your personal assets. But a trust by itself, a revocable trust, will not give you asset protection, and only the irrevocable trust if you're willing to give up the control. All right, so I don't have any more questions here in the queue. The last celebrity is Heath Ledger. Heath Ledger died at like 28 years old. He was super young. He had a girlfriend, not a wife, and a 3-year-old or 2-year-old daughter. And he had done estate planning. He did a will, but he drafted it 5 years before he had the girlfriend and before he had the daughter. So his will left everything to his parents. So yeah, he didn't update it after he did it. He had his child or had his girlfriend, which is, one of the first things that we say when you do estate planning, you have to update it whenever there's a big event, like a death, like a birth, like a marriage, a divorce, anything like that. So unfortunately, that got overlooked. He passed away. That will was all that was existing, and that's what the will said. Now, we all know about it, again, because it was public, and luckily his parents did the right thing and agreed to give all the money to the daughter. But it's unfortunate because we don't know what he would have wanted to do with regards to his girlfriend. One thing I wanted to add is that anybody who's attended, I completely forgot, our events, tonight is entitled to a free legal consultation with us. So you will probably get a follow-up email inviting you to take advantage of a free consultation. That's normally $750. But, we know that you're taking the time to come here tonight to listen to us. We want to honor that by inviting you to schedule a consultation at no charge for the consultation. And so that's a 750 waiver for that. And then let's see another question. Who do we put in control of irrevocable trust if our children are minors? And we don't have anyone else we trust? Ooh, good question. Do you want to answer that, Christina?
Oh, I don't know. It's a very difficult one. I mean, there are like corporate trustees that could do it. But in those cases, sometimes they only take them on if depending on the value of the trust. In my opinion, it becomes costly because they're going to charge you for every little thing that they do. So because every plan is tailored, if you still have minor children, I would really see why are we doing an irrevocable trust for you right now. Maybe an irrevocable trust is not the correct trust for you, and just do a revocable trust where you are the trustee. And if you truly have nobody, yeah, that sometimes is a problem. You know, I had a client one time come to me and she really said she had nobody, you know, not a sister, not a friend, not anyone to be anything. And, you know, we looked into corporate trustees for a trust for her. Sometimes if you're going to leave things to a charity, sometimes the charities would take on the role as trustee when they know that they're receiving the inheritance. You know, sometimes attorneys are willing to be your trustees. It's really case by case basis.
Yeah, and I would look to see, do you have any trust, you know, best friends, really close friends, trusted advisors, accountants, financial planners, anybody that you think you can trust to handle this role. I mean, it is a role, you know, you'd obviously want to talk to them about it first. But there's not a ton of work. It's, you know, a good responsibility. And they have a fiduciary obligation. So if they're not honoring that obligation, they can be removed and replaced by somebody else. So, you know, there are options out there if you don't have, you know, if you have minor children and don't have any, a spouse or something, but hopefully you have a friend or cousin or relative that can do it. Question from Sammy. Hi, Sammy. What happens if your trustee dies before you put it into an irrevocable trust? So I think what you're asking is what happens if you've appointed a trustee and then they die, which can happen. So every trust that we design has several levels. So we'll point the first person, and then the next question we ask is, okay, if that person's gone, who's next? And then if that person's gone, who's next? And we always do at least 3 people because this can happen and we do not want the trust to fail. In the event, in some cases, that everybody is dead, ultimately it's going to wind up in court. So we want to at least list a few people, or sometimes there's a catch-all where we can kind of put in language that says you can go back to the attorney and the attorney can review the file and appoint somebody that they would best honor your wishes. And that would at least keep it out of the courts. So ideally, you're going to come to your estate planning with several names for the trustees because we do anticipate that it could happen. All right, so I don't have any more celebrities stories for tonight. It's almost 8 o'clock, so you know, to honor everybody's time, we don't want to keep you too long. Thank you for all that have stayed on. We really appreciate you attending, and we're here if you have any questions.
Thank you guys so much for all being on tonight. We appreciate it.
Yes, thank you.
Thank you.
You're welcome. You guys are welcome. Thank you.